Hello everyone, and today's news on the 24th of May 2025. This week we have news about the EHRC convening with sex matters. That is, there is backroom lobbying going on. I shall read what's been going on. There is a coordinated backroom campaign. TACC, or the Trans Advocacy and Complaints Collective, has uncovered documents obtained through a Freedom of Information request revealing how Sex Matters secured privileged behind closed doors access to the Equality and Human Rights Commission EHRC in September 2024. This was not just an isolated meeting, it was just part of a deliberate lobbying strategy aimed at reshaping the interpretation of equality law, undermining trans rights and legal protections, and framing the exclusion of trans people as legal clarity. These findings expose a pattern of influence that threatens the rights of trans people and the integrity of EHRC itself. The meeting at Tintagel House. It was on the 6th of September 2024, EHRC offices, Tintagel House. Who were the attendees? Sex Matters, Maya Forstater, CEO, Director of Campaigns, Director of Advocacy. EHRC, Baroness Kishwa Faulkner, Chairwoman, and named Commissioners, legal staff. The agenda? A closed-door meeting where Sex Matters presented its views on sex, gender and law and sought to shape the EHRC's future legal direction on these issues. No trans organisations were invited, no public consultation, just a private discussion to influence policy that affects the rights of many. What did Sex Matter demanded? The documents revealed Sex Matters pushed the EHRC to simplify guidance to support blanket trans exclusions in services, frame confusion about trans identities as a legal problem, convene experts including those from exclusionary groups like World Rugby to give false balance, promote biological sex as the sole legal category in equality law. The follow-up email beyond consultation. Just 3 days after that meeting, Maya Forstater emailed Baroness Faulkner directly. This wasn't a casual exchange of views, it was a strategic lobbying document, a clear attempt to influence the EHRC's legal direction. Forstater's email included a 2010 draft of the EHRC's Code of Practice, which removed key protections for trans people. Polling suggesting the public supports clear language that excludes trans women, pushing for a legal framework based on exclusion, not inclusion. A selective list of legal cases framed to make trans inclusion seem like a legal risk, omitting cases that affirm trans rights. This wasn't consultation, it was a blueprint for exclusion, drafted by an activist group delivered directly to the EHRC's chair. The model policy for schools. Around the same time, Sex Matters launched a so-called model policy for schools. This document advocates for sex-based rules on facilities, uniforms and record keeping. Frames trans inclusion, particularly for gender questioning children, as a safeguarding risk, suggests that trans children's identities should not be respected without parental approval, and promotes rigid binary definitions of sex across school policies. Sex Matters shared this document directly with the EHRC, aiming to influence how schools handle gender identity and ultimately to restrict trans children's access to support and recognition in education. Misrepresenting the Equality Act. Sex Matters has been consistently called out for presenting a deliberate and misleading interpretation of the Equality Act 2010. They argue that the law allows for default exclusion of trans people, especially trans women, from single-sex spaces, but this is not what the law says. Under the Equality Act, any exclusion must be case by case, proportionate, and means to a legitimate aim. There is no blanket right to exclude trans people. The Act protects trans people under the characteristic of gender reassignment, and the courts have repeatedly affirmed that trans women with gender recognition certificates are legally recognised as women. Sex Matters framing erases this legal reality and promotes a narrow exclusionary agenda under the guise of clarity. Distorting case law. Sex Matters builds its case for exclusion by cherry-picking legal rulings, but their framing is selective and misleading. For instance, they cite Adams versus Edinburgh Rape Crisis Centre, a controversial employment tribunal decision that undermined the privacy rights of a non-binary employee, a ruling criticised for failing to uphold basic protections under Article 8 of the European Convention on Human Rights. They point to workplace toilet cases, treating them as general legal precedents for excluding trans people, even though these cases were fact-specific and do not establish broad rules against trans inclusion. Sex Matters ignores key legal principles. That trans people are protected under the Equality Act as having the characteristic of gender reassignment. That any exclusion must be justified as proportionate and necessary. Trans women with gender recognition certificates are legally recognised as women in most areas of UK law, but the Equality Act may interpret women as biological sex in certain contexts. This is not a balanced legal reading, it is a strategy to reshape equality law by misrepresenting it. What is the broader legal strategy? This is not an isolated policy debate. Sex Matters is part of a coordinated legal campaign working alongside ultra-conservative groups like Christian Concern to back cases aimed at restricting trans rights. Examples include the Doncaster nurses case supported by Christian Concern, the ongoing case of Sandy Peggy versus NHS 5, represented by Margaret Gribben, known for exclusionary legal arguments. These cases are designed to reshape the interpretation of the Equality Act and create legal precedents for trans exclusion across services, workplaces, and public spaces. This is not about clarity, it's a deliberate strategy to roll back trans rights through the courts. It is manufactured confusion as a strategy. Sex Matters' core strategy is to create and exploit confusion. They frame questions like, what is a trans woman? What does the Equality Act actually protect? Are trans women a risk in services or sports? These are presented as concerns, but their purpose is clear: to create doubt where the law provides clarity, to turn trans people's existence into a problem to solve, and to frame exclusion as the only solution. Their proposed answer? Fixed, rigid definitions of sex, and a legal framework that excludes trans people by default. Sport as a wedge issue. Sex Matters uses sport as a wedge issue, a way to push for broader trans exclusion. They focus on concerns about fairness in women's sport to argue for blanket rules across society, not just in sport, but in all women's spaces. They cite World Rugby's ban on trans women as an example and claim that trans inclusion in any context undermines the rights of women and girls. This approach uses concerns about one area to justify widespread exclusion. Schools and safeguarding, a smokescreen. Sex Matters presents trans inclusion in schools as a safeguarding risk, but their framing is misleading and unsubstantiated. For instance, they argue that schools should adopt strict sex-based rules on toilets, records and uniforms, treating trans identities as a problem to manage rather than a reality to respect. They claim schools should avoid recognizing trans children's names, pronouns and gender without parental approval, presenting this as a legal safeguard when in fact it increases harm. This approach misrepresents both the law and best practices. UK safeguarding law is about protecting all children from harm, not excluding specific groups. The Equality Act protects trans students under gender reassignment. Schools already have a duty to make reasonable adjustments and consider each child's individual needs. There is no evidence that recognizing and supporting trans students increases risk to others. By framing trans inclusion as a threat, Sex Matters uses fear to argue for blanket exclusion. This is not safeguarding, it is ideological policy making, designed to control how children express themselves and to deny trans students recognition, the care and dignity in schools. What is the EHRC's role? The regulator for all or a narrow gatekeeper? The Equality and Human Rights Commission is the UK's national human rights body tasked with upholding equality law for everyone, including trans people. But documents show that the EHRC held a private meeting with Sex Matters, agreed to listen to the proposals and considered their input when shaping future legal guidance. This raises serious concerns. Is the EHRC giving disproportionate access to one group's perspective, while trans communities and trans-inclusive legal experts are excluded? Is the EHRC fulfilling its duty to uphold the rights of all protected groups, including those with the characteristic of gender reassignment? A neutral arbiter or ideological ally? The concern is not just about legal process, it's about the EHRC promoting the agenda of a specific lobbying group, one that frames trans inclusion as the threat and advocates for stricter sex-based exclusions across services, workplaces and public life. This has real consequences for trans people's lives. Reduced access to services, heightened risk of discrimination, and a sense of exclusion from the legal protections that should apply to all. The EHRC must demonstrate it is acting as an independent, balanced regulator, not as a platform for a narrow agenda. What are the dangers of informal influence? This is not a public consultation, it is backroom policy making. The documents reveal that Sex Matters has been given a seat at the table to discuss national equality policy, space to draft and propose legal interpretations for the EHRC, the opportunity to help reshape national guidance behind closed doors. Meanwhile, trans organisations whose rights and lives are directly affected have not been granted equal access or opportunity to shape this guidance. This raises serious concerns and questions about fairness, transparency and the EHRC's role as a regulator for all protected groups. A blueprint for erasure. The documents make it very clear. Sex Matters has a coordinated strategy. Their aim is to portray trans inclusion as confusing, risky or harmful, promote legal definitions that exclude trans people from rights and spaces, frame these exclusions as common sense or legal clarity rather than a deliberate rollback of protections. This is not about clarity, it is a strategy of erasure presented as policy reform. The EHRC must be held to account, and what needs to happen now. The EHRC has a legal duty to protect the rights of all under the Equality Act, including trans people. But the documents reveal a process where a select group, like Sex Matters, has been given privileged access. Trans organisations and inclusive legal experts have been excluded, and key policy discussions have happened behind closed doors. This is unacceptable for a national human rights body. TACC has called for full publication of all communications related to the updated Code of Practice, equal access for trans organisations and inclusive legal experts in shaping future guidance, and an end to behind closed doors policy making. That undermines transparency, accountability, and the rights of all protected groups. Equality law cannot be rewritten behind closed doors. The EHRC must demonstrate that it is working in the interest of all protected groups under the Equality Act, including trans people, not just those granted privileged access to its leadership. All the documents, information and details cited in this newsreel is available via the full TACC briefing on the following link. This is not just about trans rights. It's about how laws are made, who is allowed to shape them, and whether we will allow fear and selective influence to undermine protections for all. That is all the news that I have for this week.